Good evening, everyone. My name is Betty Nordwind. I'm the director of the Harriet Buhey Center for Family Law. I'm very pleased to welcome you tonight, and I believe in very short intros, to the Professional Responsibility in the Age of Technology CLE, which is for 1.75 ethics credits. We're very, very lucky to have Jennifer Saunders, who's a very long-term volunteer at the Harriet Buhey Center, going back at least 20 years, who is a certified legal malpractice specialist in the state of California, and her co-panelist, Jeff Roback, who is the director of information technology, and they're both at the firm of Haight Brown Bonesteel, who's lucky to have them both. The way we are going to handle tonight is we're going to handle questions in the following way. You put your questions in the chat. We will stop at approximately 5:15 to answer those questions, and then take a break at 5:30 for 15 minutes. Then we will continue and stop again at 6:15 for more questions and conclude at 6:30. When we sent out the ethics credits, it did say 1.75, so we took account of that break. That's my conclusion. Jennifer, I'll turn it over to you.
Thank you, Betty. Good evening, everybody. And thank you, Jeff, for being my co-panelist on this. Welcome to this evening's topic of professional responsibility in the age of technology. As we all know, technology is both a curse and a blessing, especially over the last couple of years that we've been forced, if not anything else, to become acquainted with and familiar with in a lot of ways. So tonight what we're going to talk about is our agenda is the ways that we use technology. We're going to talk about strengths and weaknesses of the various platforms that we're all using. The third thing is what the attorney's duty is when using technology, and we'll talk about some ethics opinions that have been brought out and the rules of professional conduct that apply, and we'll talk about the potential impact on cases when we use technology. Next slide. Different ways that we use technology. I just wanted to bring these out. Obviously, emails. Some people use WeChat. We use our phones through texting. Some people actually attorneys will use Facebook. We use Dropbox. We use all different forms of modes of communication. We could use a desktop. We could use a laptop. We could use an iPad. In family law, we're going to talk about the use of listserv on social media. We'll talk about e-filing, which I know in family law just recently came out, and so there may be issues there. We'll talk about making court appearances remotely, and the LACC website with different services. We'll talk about mediation. But one thing that is important is how clients are also using technology, and the duty of an attorney to become familiar, to talk with their clients about the forms of technology that they're using, so that you can work with them and alert them in areas that may be necessary. Some daunting statistics. I'm going to throw this over to Jeff to talk about, since he has a real handle on a lot of this information. Jeff?
Sure. Let's go ahead and forward the slide. So we go. So as Jennifer mentioned, technology is growing in leaps and bounds. you know, and there's been an overall sea change of, you know, the cloud, where information moves from being in our offices or our homes to, you know, the internet at large. And it, you know, it presents some interesting challenges to doing it. But I think, you know, the reality of it is that you pretty much can't practice law without making use of technology at this point. And, you know, to put a finer point on it, one can't just assume that because this is complicated, they don't have to know it. Pretty much people are obligated to understand this technology and make rational decisions, you know, to understand risk. And one of the things we'll be talking about is there is always this balance of, you know, how secure are you going to be versus how easy is the technology to use? And it's a tough one. There's not always easy answers, but that's something we'll be talking about as we move forward.
One thing that I think is quite interesting is the statistic on workload processes through the cloud. In 2015, which was, you know, not that long ago, only 25% of our workload went through the cloud. Now it looks like it's almost pretty close to 100%. At least a year ago, it was at 94%. And the other area that is interesting too is that 62% of lawyers are using Dropbox now, or some form of a Dropbox system, whereas previously that percentage was very, very low. Pre-COVID was very low.
And I think, you know, the thing that's interesting about that is people's first reaction or first question is, well, is it secure in Dropbox? Is it secure in the cloud? In general, things are very secure while they're there. The challenge is how does the cloud know if it's you or if it's the bad guy? And that's where it gets complicated.
Next slide.
So there's really been kind of a change in the way that, you know, what causes data breaches and how computers get taken over. You know, there was a point where it was this automated stuff, like you turn your computer on and boom, you'd get captured in the internet, you know, from something on the internet. And really what we're starting to see is that humans, for better or worse, are the weak link here. And at this point, virtually all 91% of data breaches start with an email where someone clicked. And that's, you know, that's why education and understanding becomes so important. And we'll talk later about some specific tips on doing this. But the thing just to keep in mind is that most of the problems are human related. And so therefore, a lot of the solutions that we're looking at are human related as well.
And then law firms specifically.
Okay. So things to think about, and, you know, keeping in mind that the clicks are the problem. Every time you click your mouse on something, potentially bad things can happen. And so where we see people get into trouble with this is when they're doing research, if they're having to go through a bunch of social media to try to get some background on something. Social media tends to be very dense in terms of, you know, bad things. And with emails, it's really important to make sure you know who the email came from. You know, looking at who the actual sender is. You know, it's a daily occurrence that, you know, people get emails that purport to be from someone who they're not. And so those are all important things to look at.
And I would just add, this was a recent event on one of my cases. I got an email from who appeared to be, the email was coming from a co-defense counsel in a case I was handling. And I looked at it and it just seemed odd to me. And I clicked on the address and it was his name in the sender, but it was a different address than I knew he had. And so, you know, I contacted that attorney and he did acknowledge that somebody had gotten into his system and was sending out these emails, because this was an occurrence. So it does happen. That was most recent, but it's happened in the past too, where that type of thing I've noticed.
Very, very common at this point. Almost all of them, because as an IT guy, we can protect things where they're trying to use your email address. But if they use your email address, if they use their email address and say it's someone else, that's kind of tricky for us to block. And we had one like that not too long ago, where a paralegal had been in communication with 5 or 6 different people, and there was a thread going back and forth with people sharing documents and discussing it. And then at one point, one person replied to all and said, "Hey, I can't open this document. Can you guys?" And so, of course, what does everyone try to do? Well, it was not a good document that they opened. So the people doing this are very bright.
Very savvy, very savvy.
So it's something that folks don't think about a lot is, it's tempting to think, oh, I'm just a lawyer, or we're a very small law firm, no one's targeting us. But what larger companies in the finance sector in particular have realized is that their data is generally very well protected. They have entire committees that all they do all day long is think up security policies and validate security policies. But a lot of times those same firms are sharing data with very small firms who don't have any of that. And so the bad guys have really found that this is a good way in. One of the most interesting examples of this was actually, back in 2013, Target had a huge breach. It cost them $200 million to deal with. And how Target got broken into was not someone going to Target. What someone did was figured out who the air conditioner vendor is that serviced their stores, broke into those guys' computers, and from there sailed right on into Target. So this is why large firms these days are very aware and concerned. And so it's important to not feel like that you've got some security by being a small guy, because small guys are very much a target at this point. So
from a state bar standpoint, next slide, some good news and some not so good news from the statistics that the state bar publishes on disciplinary actions. In 2020, there were 17,500 new cases that were opened in the state bar court for investigation. The good news is that out of those, and this is LA County alone, so it's not the entire state, but in LA County alone in 2020, there were only 18 disbarments, 30 actual suspensions, and state suspensions were 10. The numbers are pretty close in 2021 and 2022. It's only going to develop as to whether or not any of those numbers are going to change because or as a result of COVID. So when you compare the total number of open cases with the actual suspension, disbarment, calculations, it's a very low percentage. Overall, in the state of California, we've got over 280,000 attorneys, and the rate of disbarment, suspensions, and state suspensions is pretty low. So, hopefully nobody gets to the situation where they're being investigated for something, and hopefully some of these topics that we're going to talk about and duties that we talk about will help avoid that question being raised by the bar. So the strengths and weaknesses of various platforms and technology. Jeff, do you want to briefly touch on this?
Sure. So thinking, I guess, big picture for a moment, I mean, what we're after is keeping data secure so that only the appropriate people can see it, and also at the same time making sure that we can still access that data, that we don't lose access to it. And so in approaching that, there's a variety of tactics we can take, and I think you have to look at that kind of in identifying a platform, because to some degree, I feel like people focus on the wrong things sometimes in doing this. And one element of this is encryption, and so you want to know that your data is encrypted. But probably the more important aspect of it is, how are you authenticated? How does a system decide if it's going to let you see that information? Because ultimately, that's in general what a bad guy is going to do, is try to impersonate you so that they can get access to that data. And so the big trend and the big buzzword right now is multi-factor authentication, or two-factor authentication. It's this idea, really, at the end of the day, that a password isn't good enough. And so any service you're using that only needs a password to let you in can and will get broken into. Microsoft released a statistic saying that once people moved to a second factor of authentication beyond passwords, that email break-ins dropped by 90% almost immediately. And so in picking a platform, that's one of the big things that you want to look at is this idea of, how are they authenticating you, and are they allowing you to use multi-factor? I think the other side of it is are you using a business platform more globally? Are you using something that's targeted at home users, or are you using something that's targeted at business users? And a lot of times the same companies will have both. Google has Gmail for home users, and they have Gmail for business users. And if you're not paying anything for it, if it's free, chances are it's not a great system. Kind of the thought on that is that if you're not paying for the product, you are the product. And so they're finding some other way to get information about you. And so what I would encourage you to do is make sure that you're using products that are targeted towards business. If you're using Google, you want to use one of their business plans, not their personal plans, and the same on the Microsoft side of things. They have free accounts that are really designed for people at home, and then they have business accounts that are designed for people who have information that they're responsible for protecting. And once you move into these business type accounts, that's where you get better protection against malware, you get a lot more options for encryption, and you get these higher levels of authentication that are requiring, multi-factor. So I think those are kind of the big things that I look for in picking a service.
And one of the aspects to it is sort of an extension of not only what are the strengths and weaknesses of our systems as attorneys that we are using, but also who are the vendors that we're using, and how are they using our system, and what controls do we as lawyers have in place for access that we are giving those vendors potentially of confidential client information, or work product, things along those lines. And one of the state bar opinions or ethics opinions that came out in 2010 talked a little bit about this, and we'll talk about it later. But there's a lot of things that an attorney can do in communicating with those vendors to protect themselves, obtain assurances. And I don't know, Jeff, have you dealt with that situation before? So.
Oh, sure. And it gets tough because, unless you're a security expert, it's hard to know the right questions to ask. And I think a lot of times, what you have to do is to some degree rely on the larger vendors, because, the Microsofts and the Googles of the world, have to show levels of compliance. And then if it's someone that has a brand new piece of software that sounds great, it would be pretty tough for you to do a thorough evaluation of it. And that's going to kind of be a recurring theme here, is that none of this is easy, and it's not, oh, just use this and you're fine, because what works today is not going to work tomorrow. It's more about, what I talk about a lot with the firm is it becomes a culture of security, a culture of thinking about at all times, where is the data going, who has access to it, and how am I protecting it? And so those are the kinds of thoughts that you have to go through, and don't unnecessarily share your data just because it's easy. Don't put things out there. and some of it is simple stuff like don't make one spreadsheet that has 100 people's social security numbers on it. You're just kind of asking for it at that point.
Thank you. So what the State Bar looks at in terms of the duties of us as lawyers, they look to various rules on these opinions. Next slide. The first rule that they look at is to competence. And the ABA model rule and the California rule is rule 1.1. They look at confidentiality, rule 1.6. They look at communication, rule 1.4, and they look at the supervision in firms or even in a solo if you are using a secretary or some receptionist, somebody who's assisting you, a paralegal. Rule 5.1 to 5.3 will come into play, and we'll talk about each of these. The first rule of competence. The rule itself is there up on the screen on your left. The lawyer shall not intentionally, recklessly, or with gross negligence or repeatedly fail to perform legal services with competence. And then it defines competence as any legal skill or legal service to apply the learning and skill that is reasonably necessary for the performance of the service. And that's in comment 1, which the California State Supreme Court approved. It specifically includes technology, and that was just added. It's been in the works, but it was added last year. And that follows along the ABA comment 8 under this rule, which also includes technology. So when we talk about what is competence, you have to look at a couple of different things. First of all, you need to evaluate a lot of aspects to the question of competence. You need to evaluate what actual tools are you using that use technology. So you're using a computer, you're using a desktop or a laptop, you may be using an iPad, you may be using an iPhone or some an Android. So you look at the types of tools that you are using. You look at what specific technology under those tools you are using. So are you filing documents through the court's e-filing system? Do you know that technology? Are you making appearances in court remotely? Do you know that technology? Have you used that technology, and can you use it proficiently? And I have been, and I'm sure a lot of you have been on remote appearances in cases where somebody is also on an appearance in that same department and they have their audio on at the same time that they're talking to a client or opposing counsel, maybe on that case, maybe on a different case. You need to be very attentive when you're using the technology that is handed to you, because you could be waiving a privilege. If you're talking to your client, you could be waiving your own work product, your strategy in a particular case by disclosing all of this openly to the public in that type of format. So we have a lot of good tools that are easy to use, they're accessible to use, but just like when emails first came out, or technology first started and we started using the technology, we should not be become reckless, I guess you could say, in its use, and just assume that well, nobody's listening, or whatever. You have to know your system. So you should go on, you should practice it beforehand and make sure that, you know, if you're appearing in court, you don't have a bunch of towels or, you know, things like that in the background. It's as if you are actually in a courtroom. And I think that your presentation to a court, when you're presenting yourself in the formal method that you would use if you were physically present, is what judges appreciate that, and they respect that much more than if you're you know, popping around doing multiple things while you're also on this appearance, or you're putting your coat on or your jacket on, or doing something that's not related to that court appearance. If it's not something that you were not doing when you were physically in the courtroom, then maybe you shouldn't be doing it on the screen, because that's what the judge sees. And that's what the courtroom sees. They have the big screens up in the courtrooms now. So everybody sees exactly what you're doing. They see who you're talking to, and that you're not paying attention to the appearance. So we just have to be cognizant of those things. You know,
if I could throw in just for a second, interestingly, this is something that came up even before COVID and before Zoom, even when we would do video conferences between locations. I've had to kind of poke my head in and remind attorneys that the microphones are very sensitive. And when they're whispering to their client, the other end is hearing very clearly every word they're saying.
Right.
And
Right.
so it, you know, but it comes down to kind of understanding the technology to understand what can affect the outcome.
Right, exactly. And I know in family law, there's Dissomaster, there's Profitizer, there's Family Wizard, which the attorneys may not use themselves in the practice, but you still need to be aware of what the technology is so that you can properly advise your clients, or you can then work with the forensics that you have on the cases. And best represent your clients. It's knowing the technology and knowing how to handle that technology in each of your cases. So there is a state bar opinion. It's 2010-179. It's 12 years old now, but it goes through an evaluation of what steps an attorney needs to take in analyzing their competence in handling technology. The case itself, the fact pattern is not, it was a Starbucks laptop type of a case. But what the opinion talks about are the 6 things that an attorney should evaluate in terms of technology. The first one is the level of security and whether or not the attorney can take reasonable steps to increase the protection of that, whatever it is that you're doing. The second thing is the legal ramifications if there is a breach of whatever it is that you're doing on that system. The third is the degree of sensitivity of the information. Are you dealing with tax returns of a client? Are you dealing with any kind of financial information of the client? Or are you dealing with, maybe it's even a paternity case that is a confidential matter altogether. It's not accessible to the public. That degree of sensitivity needs to be at the forefront of your mind when you're using technology. The fourth is the possible impact to the client if there is an inadvertent disclosure. It's not like you're intentionally doing something to leak this information. So what is the impact on the client? That needs to be a consideration in your mind. The fifth thing is the urgency of the situation. if you did learn that there was a breach of some kind, or you did learn that perhaps somebody had gotten information that you were transmitting using some type of public Wi-Fi system, how soon did you address it? And what steps did you take? The sixth factor, which is also extremely important, and I think I mentioned it initially, is what instructions did your client give you, and what were the circumstances that those instructions were given in? So my philosophy is technology is something that should be discussed with the client at the outset of any type of retention. And when you discuss technology with the client, it's not to control what the client is doing or how the client is using technology. It's to, first of all, tell the client, look, I'm asking you what forms of communication you're using, what forms of technology you're using, because it could have an impact on our communications. It could have an impact on our case, and I need to best represent you. And then from that information, you can then gauge, okay, how are you going to communicate with your client? What is the best protocol for that? How are you going to share information with your client? Are you going to use a Dropbox system and share it only with the client? Are you going to talk about passwords with the client? And if the client, especially in family law, they've got spouses, sometimes children, they all have the same password, or they know your password. And so instruction to the client, you need to change your password on these things, or you need to create a new account and not use the former account. Whatever the situation may be, the importance is to comply with this rule of competence that we have out there, and it's always changing, is to address it at the outset and have a clear path, at least between you and the client, as to how you're going to address it. Some tips that I think are important in evaluating what you're doing is, and compliance with the rule of competence is, to acquire the knowledge yourself of the systems that you're using. When you go out and you are using some technology that you have in the public view, if you will, is that information secured? The second tip is to consult or hire someone who is competent in technology, and work with that person to help you. And then the third tip would be to train yourself or train with somebody on all of the systems that you're using, and to update that on a regular basis. And I know Jeff mentioned it earlier, is, our systems are changing constantly out there, and there's updates to systems and so forth, and it's sometimes impossible, but or seems impossible, but the strength is, I think, comes from an ability and the effort to stay on top of it, and not say, oh, I'll do that tomorrow, or I don't have time for this. None of us have time for it, but again, we're charged with this duty of competence, and it's not something that anybody should just say, oh, I'll just do it when I'm free, or I'll do it in the evening, because you're tired. And so I don't know, Jeff, do you have anything that you want to add to this?
Yeah, I mean, this is something we come up with a lot, and I think there's kind of two challenging approaches to this, where I think sometimes people feel like I can't be an expert on this. There's no way I can understand all this stuff, so I'm just not going to do anything. It's not my problem. And I think to a certain degree, obviously, it's understandable because it's even to professionals, it's very confusing sometimes. But what I see happen sometimes is that folks, because of the fact that they don't understand all the details, they overlook some things that are pretty much common knowledge at this point. And a lot of times we kind of can work through that with a smile test. I can ask someone, I mean, really, did you think 1, 2, 3, 4 was a good password? And they'll smile, and then we'll say, okay, so, well, I don't understand all this stuff. Yeah, but we pretty much all know that, right? Or like Jennifer said, if you're using the same password to protect your client's data that you're using to log into your child's school's website, probably not a good thing. And this is not super complicated. This is not getting into levels of encryption and decryption keys. So I think there's that. But I think the other side of it too is it is intimidating. And it's tough, and it is one of these onions that the more layers you peel back. But I would say there's a lot of good security training out there, and I would definitely avail yourself of it, because it really becomes a mindset more than anything else. It's not like learning Microsoft Word, and once you kind of got that down, you're kind of good for 30 years. This is a mindset. It's an approach, and I think it's a matter of due diligence, and it's a matter of taking due care with the data that you've been entrusted with. And I think it's an element of that. And that's, going forward, that's just going to be part of what has to happen.
Yeah, I agree. The next duty that we have as professionals is the duty of confidentiality. And I'm sure everybody is aware you have the duty to maintain your client confidences. And it's both a rule of professional conduct. It's also a business and professions code section that we as lawyers have an extremely high duty to protect those confidences. And the consequence, obviously, of not maintaining those confidences is a waiver of the privilege. And we don't want that. And even the restatement third of the law governing lawyers at section 79 said the privilege is not waived if the attorney took precautions reasonable under the circumstances. And that is a mouthful, but that's why it's important to really be cognizant of what you're doing, where you're doing it, why you're doing it, and most importantly is what precautions are you taking as the holder of this secretive communication with your client to protect it. And there's a fairly recent state bar formal opinion that came out in 2020. It's Rule 203. And in that opinion, they talk about 4 different scenarios, all dealing with confidentiality, different circumstances. One of them is the use of a laptop. And whether or not you're using a laptop, whether it's a laptop that is issued to you from the firm that you're with, or you're using your personal laptop. If you have personal client information on that laptop, then your obligation is to protect that laptop. And how can you do that? Under the first scenario, the attorney had a firm-issued laptop, and he ended up getting breached. The data was the laptop was stolen. And what the bar talked about was the fact that in that particular instance, there was no confidential information that was actually on the laptop itself, because the laptop was just the means by which they obtained the information through special VM software. But the State Bar opinion talked about interesting factors that you may want to consider in your practice. And one of those is the ability to wipe the computer that you were using that may have been stolen. It may have been somehow breached when you were using it. And it may have had confidential client information on it. So what is your ability to remotely wipe that computer, wipe that laptop of all of that information, so that if they did get into it, they wouldn't be able to access it? That's the first scenario. And under that scenario, because the firm had the ability to wipe the computer of all information so that it could not be obtained, and they didn't have any specific proof, I guess, that it had been breached in any way. The bar stated that in that scenario, there was no duty to disclose any of the circumstances of that laptop information to its clients. There's a second scenario that it talks about where there was a cell phone, and the attorney had used the cell phone, smartphone, to access email and text clients. And in that particular situation, and I know we've all used our cell phones, sometimes a lot of us have lost cell phones or misplaced cell phones. And in that particular situation, the attorney had gone to a restaurant, had dinner, forgot his cell phone. It was in a tote bag that he or she had carried, and left it at the restaurant. The attorney realized when he got home that he didn't have a cell phone. He called the restaurant was closed. He didn't know what happened until the next morning. He was told that the manager of the restaurant had found the tote bag, found the cell phone, had put it into the safe, and that no one had access to it. Everything was there. So again, in that situation, the bar said there was no duty that was owed to the clients to advise them of the situation, because you were confident, the attorney was confident that that phone had not been touched, that the information had remained confidential and had not been seen by anyone. There's a lot of situations where that is not the case. That attorney was lucky, and no information was obtained. But there are situations where we've simply lost our phone. And so again, one of the tools that you might want to explore and determine if it's available to you is, can you wipe that phone remotely of all information, so that any information that is on that phone cannot be obtained. You would also want to consider talking to someone such as Jeff or another expert in technology to determine whether or not there was any access attempted to any of the sources that were on that phone or laptop, whichever. So that in that situation, if you did obtain information that there was a possibility, then you might want to consider whether or not any clients need to be advised of that situation, so that they are protected. A third situation that this bar opinion talks about is phishing. Not F-I-S-H-I-N-G, but P-H-I-S-I-N-G, which Jeff talked about earlier. And that is something that all of us, as he indicated, we have seen, and hopefully very few of us have actually experienced the repercussions of. But it is out there. It is becoming an ever-changing tool that hackers will use to get into our systems. And I think I've read some information, I don't know, Jeff, if you have anything to add on this, that sometimes even the sole practitioner's information may be right for hackers because they can use information in that system in order to gain access to other systems. I don't know if you want to talk about that briefly.
Yeah, oh yeah, absolutely. It's kind of like we talked about earlier, that, you know, smaller folks can be a gateway to larger organizations. But the other side of it is sometimes the hacker doesn't know what they have, and they don't have to know, because all they have to do is steal the data and then tell you, I have this data, I'm going to post it on the internet unless you pay me $100,000. They don't have to know exactly who that's important to. All they have to know is that you can't let that data go, or it's going to put you in a real bad spot. Or even further, you know, the crypto malware that has been going around, what would happen if suddenly every file that you have was gone? You know, that's all a hacker has to threaten you with, and they absolutely can do that. They can destroy all your data, and if you don't have good backups and things like that, you know, so absolutely, you don't have to be large to be a target. And, you know, sometimes smaller folks are more at risk, because, you know, it would be a lot harder if you don't, you know, you only have so many clients, and if you have to tell all of them their data's gone, you know, you're in a bad spot.
Right. And that's where, you know, with phishing, it's not just you yourself, but it's anybody that has access to your system. And so if you rely on a paralegal to go through your emails, if you rely on a receptionist, whoever it is, an associate, anybody in your office that has access to your emails, or has their own email in that same system that you're using, is exposing information that you have that is confidential for your clients. And so it's important to protect that. It's important to make sure that your staff and the people that are working with you on these cases are properly instructed and thoroughly instructed. And one of the third scenario that this state bar opinion talks about is exactly that, is a phishing situation where a receptionist who was clocking out for the day checked an email, clicked an attachment to that email, and the firm was hacked and had to pay ransomware in order to get their system back and operating. So it's constantly moving, and we just have to be very aware of different situations, and that your people and yourselves are taking the time that it's necessary to make sure that you are protecting the information. And some tips in terms of this confidentiality issue is really an evaluation of your client data and what levels, again, what is the level of security that you are providing for that data. So if you think of it, if you compare it to when we used to just work with, you know, our yellow pads and our hard files, it was sort of easy because you could put it into a locked cabinet and leave for the day and everything's great. we have to think of it sort of in that same way, is pretend as if the information that you have, wherever you have it, is in that locked cabinet, and that you've taken steps to make sure that it's in that locked cabinet that is possible for you to take. Obviously, we can't, stand over everybody that is helping us out, but nevertheless, it's to remain diligent and to be vigilant on all of these things. And I know that we're approaching some time here in terms of questions.
Right. So Jennifer, I don't know, people aren't, either I'm missing the questions, or please ask your questions. Elizabeth, I know you raised your hand at the very beginning. Did you want to ask a question just verbally?
Elizabeth actually had to leave.
Okay. Well, I've got a couple of questions to start off. I just realized I was with my mother at UCLA Hospital on Sunday, and I was trying to be diligent and do some work. So I hooked up to UCLA Med Guest. And as we're talking, I just realized that probably wasn't a very good idea. I wondered if, and second part of that same question is, Jeff said, like at the Harry Buhey Center, we have laptops, right? To the extent that you do not download into your laptop confidential information or receive it through an email, in my case, it's more financial information, whatever, then it means it's still protected. This is a question, that it's still protected through our server security because it hasn't been downloaded into mine. Is that correct? Have I understood what you said? So it's first and second question, Jeff.
So you're going to hate me, but the answer is it depends. When we look at security and protecting information, there's kind of two concepts that we look at. We look at, is the information protected at rest, meaning where that data sits, and then is it protected in transit? And so, there's a couple things to be concerned about there. I mean, if you're using a public Wi-Fi, potentially someone could see that data as it moves back and forth. So that's a concern. And there's mitigations for that. There's ways to work around that. And then, is that information on your laptop? And if you stepped away and someone grabbed your laptop, how do we protect that? There are methods to work remotely where none of the data resides on the laptop. That's what we do at Haight Brown Bonesteel, that the data never leaves the firm's data center. But those are somewhat complex to set up and use. And so it kind of depends on the specifics of how you're set up, unfortunately to say. But those are very valid concerns. What I would say is, if you're ever in one of those situations where you're using a public system or a system that's not your own, and you get one of those warnings where your computer suddenly says, warning, this is not valid, that's a huge deal. That's the scariest message you can possibly get on your computer, even though it doesn't look like it. Because what that's telling you is the stuff you think you're encrypting, someone else is decrypting. Now, there are some times where that happens without it being a huge deal, but if I would say anytime you're somewhere on a public Wi-Fi and you try to go to a website and you get one of those warnings, stop what you're doing and ask someone, because that's where it gets really scary. Because what people will absolutely do is they'll go to a Starbucks, they'll set up a fake Wi-Fi with the name of Starbucks and capture every piece of data going in and out of the place. And
I was just going to say, Jeff, that this State Bar opinion that I referenced, 2020, the fourth scenario is exactly what you described now, that somebody had gone into a Starbucks or a coffee shop and used what appeared to be that coffee shop's website, but it turned out to be actually a fake coffee shop website.
Yeah.
Sorry to interrupt, but
no, it's fine. It's trivial to do. Someone could literally take a laptop, boot from it, and then just leave it in the corner. And that is the fake thing all day long, and it's just capturing data. So you do have to be vigilant. And unfortunately, that one warning is all you get. But in general, unless you have good security measures in place, public Wi-Fi is probably not something you want to be doing. The Wi-Fi that's built into your phone is significantly more secure to use. The personal hotspot thing. So I don't have a definitive for you, unfortunately, but hopefully that gives you a framework to think about it. Does that help?
Yes, I mean, the takeaway for me is I shouldn't have done it. And I should have used it only for word processing, which wouldn't have got me into the internet. It was an exposure, and to the extent I have sensitive data downloaded or sent to me through an email, it was all exposed.
Mm-hmm.
That's what and I was, maybe lucky or not. I have one other question, and there's a couple of others. Jennifer, can you give us some examples of the technology conversation you would have with a client? Would you say, are you using Facebook? I mean, do you have a checklist that you ask clients? Could you go into that?
Well, my clients are attorneys, so I kind of assume what they're doing. But in terms of family law, what I would run through is, do you have a cell phone? What communication do you use on that cell phone? Do you have email on that cell phone? Do you use texting? Do you use WeChat? WeChat is it's a whole different ball of wax in and of itself. And you establish, what are your passwords for that? Do you have different passwords? If you have the same passwords that you had before you separated from your spouse, you need to change those passwords and only keep those passwords for yourself. And they shouldn't be anything close to, the former passwords that you had. You want to find out if they're using social media and what forms of social media are they using. You want to make sure that they're not talking about the case, whatever case it is, if it's a divorce case, paternity case, whatever the issues are. You just want to make sure that the client is instructed not to speak in that forum on, my attorney said we're going to do this, or, we're going to, drop a bomb on, with this smoking gun document that we found, type of thing. It's going to get back in some form or fashion. It's going to get to the other side. And that's what you're trying to avoid. And you need to impress upon your client the need to not engage in that type of conduct. You can't control the client, but you can at least alert the client. And if you can do it in the form in writing, you should probably do that, which is why I said initially it's something that should be addressed at the outset of your retention in a case, whatever form it is, in some form or fashion, and make it as simple as possible with the client so that the client fully understands. But social media is a different issue altogether, which we'll talk about a little bit later on. Hopefully I've addressed that.
So Jennifer, this is one of my last questions, or last one, because we should get started again. What would, in terms of just normal communications with clients, back and forth, email, back and forth, maybe sending a document like an income and expense, all of that. What are you recommending? I mean, if you're your average law firm or you're a sole practitioner, what are you recommending that people do in terms of security just between the two of them? Besides not you doing it at UCLA Hospital. Forum,
well, I think that the password is the number one thing that you need to address with the client, is make sure that maybe you could have the client set up a special email account that that client is only getting emails from you or your firm in connection with that particular case. And it would have a completely separate password so that, you know, things are not, you know, all out there. I know that there are levels of security depending upon, you know, the mode of email system that you're using. I'm not proficient in all of that, but you know, you need to look at whatever the security is. I have heard rumors, and I don't know that they're true or not, that a Gmail account is not a secured email system. But you know, I can throw that to Jeff, you know, what you've heard or experienced, but you know, it is free. And sometimes that's the only thing that we have that we can communicate with our clients on.
Right.
So.
Well, so here's the thing. I really try to discourage people from using email as a way to move documents back and forth. And yes, I know it's convenient, and yes, I do it myself. This kind of comes down to what Jennifer was talking about earlier, is the documents you're sending, how critical are they? What would be the impact if this document was disclosed? If it's a letter that is going to be public record immediately anyway, sure, send it in an email, not the end of the world. But if it's something that would cause grave damage if it was released, I would really look at all the different email services have a way to, rather than attach a document to an email, that the email has a link to the document. And so after receiving the email, the person clicks the link and downloads it. And, you know, Microsoft has this, Google has this, there's add-ons that you can use. But the concept is that it's less about the email going through right now, because obviously the person's going to get it and click on it. What it's about is that document not being there in that email forever. Because what happens when you use email as a way to send documents is every document you've ever transmitted is sitting there in a mailbox. And it could be a year from now, you know, anyone that gets access to your email suddenly has every document you've ever sent. Whereas if you had sent it with a link that expired in 30 days, now suddenly that information's not there. So I would, when you're dealing with documents that are highly confidential and that would cause damage, I'd seriously look at not using email as a method of transmitting those, because it is subject to that. And, you know, to Jennifer's point, the free Gmail is not going to be as secure as the paid Gmail. You know, Google Workspace is what they call it now. And, you know, that has additional precautions built into it. But, you know, if you're using a free email account, I mean, is it worth $20, $30 a month to move up to a higher level? I mean, I would think so. You know, again, if something's free, it's not because they're kind people. It's because either they're not giving you the level of protection that you need, or more likely they're using the information to try to mine information about you to sell to somebody else. Neither of which are things that really are appropriate for a professional. And I guess,
yeah, go ahead.
No, I was just going to say, and just kind of following on, and I think this follows along well to Jennifer's last slide, that the security mindset here is thinking about where that data resides, and anywhere that data resides, how are you protecting it? So it's your phone, it's your laptop, maybe it's your iPad, that one night at home you downloaded something to because you wanted to work on it. Now that device is in scope, as we call it. That needs the same level of protections as everything else. And, you know, that's where you have to think about those devices and all the different ways of protecting them. But any device that touches that information becomes in scope. And that's kind of one of the challenges with email, is if you've got all these documents in your email that you've been sending back and forth, and then you're at your sister's house and you want to use her computer to check your email really quick. Well, gosh, how much of that's now on her computer too? Just because you logged in to check one quick email. So those are the things I would think about.
Okay, so the last question is again about phishing. How concerned should we be about phishing to gain access to our devices?
Jeff?
It's huge. It's kind of like we said. I mean, phishing is the mechanism by which breaches occur, and 90% of them are coming from someone clicking. It's a huge, huge, huge concern. If there was one thing that, you know, I could implore people to do is to think carefully. And, you know, sometimes it's a small thing. I mean, we've had it happen where, you know, I've gotten a call from an attorney on a Saturday saying, "Oh my God, I just bought a bunch of iTunes gift cards." I said, well, it's okay. That probably wasn't what the partner was, you know. Does your partner really seem like the type that would need iTunes gift codes in the middle of the day? Probably not, but limited scope of damage there. But, you know, the other ones that we've seen, you know, are where someone will send you a phishing attempt and there'll be a link in there. You know, one of the ones we're seeing a lot of now is where, you know, it'll say, "Congratulations for your purchase of 5 new laptops. They're on their way. Click here if you need to discuss the order with us." Okay, well, you know, and so for a variety of reasons, you know, people click on them. And what's interesting, though, is that we're seeing a trend, and really even I'd say in the last 6 months, where the hackers have kind of gotten to the point where people like me have beat it into everyone's head not to click on links. And what they're actually starting to do is just put in phone numbers. And so it'll say, you know, if there's a problem with this order, call this number. And then you call the number and you're on the line with a very professional scam artist. And they can usually in a few minutes talk you into doing something that takes over your computer. And so there's a lot of ways we can do it. But yeah, email is the primary form of contact. I mean, there was a point where it was USB sticks, and that's what we were worried about, is you were going to get a virus and bring it in on the USB stick. But now it's email. That's the point of entry. It's the one thing that your system pretty much has to allow in from anywhere in the world.
Okay.
You know, one thing I would mention on that, and I know we're going over the time allotted, but I've had a couple of cases over the last, I would say, 6 years, where I've gotten emails from an opposing counsel in a case, and it had an attachment, and it was just, you know, you get a gut feeling, and obviously you need to know your opposing counsel, but I sent it to our IT people to check, and 2 emails from that same attorney they were spam phishing emails. And you know, it happens even with counsel. I mean, you're not limited by where this spam can come from. And so it's, you know, when you are looking at emails, you need to be very cautious. And there's even times where I check my email, and we all check our emails on our phones. And sometimes you get an email, and it's just like, I'm not going to open this one until I get into the office. I can see it on a full screen. It's just not something that, at least in my view, we can just rapidly scroll through and answer and address really quickly anymore, because they're out there and they're looking for information, and nobody is safe is not the right word, but we're all vulnerable to an attack. And it may not be for your information, it may be for someone else's information that they may gain access to. So
Jennifer, in the example you just gave, was the attorney, the opposing counsel, did they use was it their real email? I mean, what alerted you to its suspiciousness?
At the time, just different communications from that attorney just caused me to be suspicious. You know, saying that they were going to send media out to the courthouse on the day of a hearing, just weird things like that, that is not ordinary. It just caused me to be a little bit suspicious, and I'm extra cautious, I guess you could say. But you know, it was just the circumstances. So, you know, I think that the lesson there is you really have to know who you're dealing with on your cases, whether it's an attorney, whether it's a pro per, whoever it is that you're dealing with, you need to know them, and you need to be careful in any form of communication that's electronic with them.
Yeah, go ahead.
I was just going to say, to answer your question, those are especially tricky, because if this person's email was broken into, the person sending this email was sending it from him. So it's not a forged email address. It really is from him, or at least from his email. It's just not from him. And, I think looking at the diction, looking at the vocabulary, the likelihood of that person to say those things is important. And something we've seen too is it won't necessarily happen right away. Someone will break into someone's email and they won't immediately start sending this stuff out anymore. What they'll do is they'll watch and they'll wait for a good moment. I've seen this happen where someone's email will be broken into and they'll wait. And then there's back and forth dealings, maybe finalizing a contract. Everyone's agreeing on the terms, all of that. Okay, great. We're ready to transfer the funds. Then the person jumps in and says, great, here's where we want to send the funds. And away they go. So it's always being aware of, and then sometimes it's putting protections in place. I mean, a general rule we recommend to people is, anytime there's a wire transfer involved, there has to be a vocal confirmation, period, because it's just too easy to forge that kind of stuff.
You want to repeat that? Because I think some people on the phone, it doesn't happen at the Harriet Buhai Center much, but can you repeat that one more time? If it's a wire transfer, there should be.
The policy that we ask people to put in place is anytime there's a wire transfer that's going to happen, or if it's an HR person, if they're changing someone's direct deposit on their bank account, there has to be a verbal confirmation. Pick up the phone, call them, confirm it. It takes 2 seconds. Because it's impossible to know 100% for sure that email's there, and especially with wire transfers, because once the money's gone, it's gone. You have to do that because it's far too easy. There are people who specifically watch LinkedIn. They wait for a controller to start at a firm, and as soon as a new controller starts, they immediately send an email from the CEO asking them to wire money, because they know people who are new aren't familiar with what the CEO wouldn't ask. They're in a position where they want to look good and act quickly. So certain things, and whatever that is within your firm, generally anything involving money, get a verbal confirmation. It just takes a second.
So the last question is, some people on the call are solo practitioners. They're not lucky enough to have an IT department or an IT firm. What do you recommend for someone who really is operating kind of on their own and can't necessarily just call an IT person up? Do you say ignore suspicious emails, be on guard, and what do you recommend?
I mean, that's a good question and a tough one. I mean, there's a lot of general guidelines, but like we've talked about, they've changed. I mean, I think there's a lot of good training and best practices out there. The problem, again, is just there's so much of it. I will do that. Let me find a good resource for people, and I assume you're able to send stuff out after the fact. I'll find a good resource for people to refer them to, and then I think that'll be good, and it'll And again, understanding it's not a one-time thing that you read this, you check all the boxes and you're done, but it's going to be something you do on an ongoing basis. But there's definitely resources out there, Microsoft, Google, all the others, because they want people to be secure. None of this helps them. So there are resources, and I'll find you a good one.
Oh, that's great. And I'm going to just ask one question, which is sort of a summation and a repeat. To the extent that lawyers are communicating with their clients using very common software, not on the business side, but Gmail or Yahoo or Hotmail, you're advising that is really, perhaps next to phishing, the most dangerous thing you could do. I just want to kind of make sure we all walk away with that concept.
I mean, and I will tell you, even in my personal life, I sometimes have my accountant that wants to say, "Oh, I'll just email you a return." No, you won't. Just email me my return, and you kind of sometimes have to take a stand. And I also understand that, clients want to do what clients want to do. And then the best thing you can do, kind of to Jennifer's point, is document the fact that the email is considered an insecure transport medium, and it's really not the best way to do this. And, when you're the client, you get to make those choices. And when you're not, all you can do is recommend. But yeah, I would not move secure documents through email. unless you're using an advanced form of encryption and, you know, taking, but standard run-of-the-mill email, no, it's not a good way to send documents.
Well, even documents themselves. I mean, what if it's a confidential communication about the case
Yes,
strategy?
same thing.
I mean,
Good
it's
point.
not just the,
Yes.
because I've communicated and seen lawyers who themselves are using Gmail as their thing. And you're saying there's a distinction in an account between a professional Google Gmail and not. I mean, lawyers can sometimes, let's just say, be cheap and, you know, go for the cheapest, and they think they're sort of beating the system when
Right.
you're saying to us, you're not.
I mean, again, look at what the very large firms do. I mean, and the banks are kind of at the forefront of this because, of course, that's where the money is. And so they're a target. And if you've had much communication with a bank lately, it almost always comes in the form of one of those really annoying emails that says, click here to read the email from your broker. Gosh, that's annoying, but there's a reason they're doing it that way. It's protecting them and it's protecting you. And I think attorneys kind of have to start approaching it with that same mindset.
Well, and from the standpoint of, you know, we talk about what does the attorney do in terms of their communications, but what is the client sophistication on technology? And are you better off, you know, you process all of these questions and try to develop answers in your own mind. Is this particular client better off getting a formal letter from me that I put in the mail to them as opposed to sending something through email, just because maybe you don't, maybe you're not confident that that client is protecting the information that you're sending them, and that there is a possibility, however strong it may be, that confidential information pertaining to that particular case could be disclosed to the other side or to someone that you don't want to have that information. So it's just a process that we all need to develop in our mindset, you know, just like we have done throughout all of our years practicing. It's just become sort of the crashing wave on us in the last couple of years that we're all trying to figure out, you know, what do we do in this situation or that situation. But that would be something that I would think is a process that we need to go through. Is, you know, is this a client where we may want to consider just using the, you know, I'll call it the ancient days of communication, of, you know, sending something in the mail, and that way at least we're not using technology, so it may be protected, more protected.
So our pro bono director said, this is both fascinating and frightening. I want to just say one thing to you. Something Jeff said earlier, I found very comforting, because what Jeff said was you have to create in your own office, no matter how small or big you are, a culture of security in which you're kind of always kind of thinking about it. And I just want to give you the example at the Harriet Buhai Center. So within the last 6 months, maybe 9 months, we put in 2-factor identification to get into our server, 2-factor identification to get into our email. And just this week, I talked to our IT person and he said, we need to put in 2-factor for the staff using Slack, because for various reasons.
Yep.
So it's a start. You know, like tonight I learned I will never go to UCLA Hospital and think I'm being smart connecting to the internet because I'm doing work instead of just exposing everything on my computer. So it's a process and it's layered, and you hope, God, you're not going to get hacked or held up for ransomware. And that's how you have to do it. And you have to go from putting your head in the sand to, which is what I would have described myself up until about the last 9 months, and you have to just move forward. That's what I think. So I thought your description of culture of security was a good one, Jeff.
I think
Yeah.
that's extremely important. And, the purpose of this is not to frighten people or, say, hey, the bar's going to come get you tomorrow kind of a thing. It's more just to let you know what is out there and that you can't put your head in the sand. And you just need to educate yourself and pretend like all this technology that you're using is boxed up and put in a file cabinet somewhere. So everything's protected.
Right. And none of it's 100%. There's nothing you can do to totally protect yourself, but there's a whole lot of things you can do to make yourself more protected, and they're not that hard to do, most of them.
Well,
And I just, Jennifer, so in terms of the state bar thinking that you're being negligent, I would assume that if an attorney is communicating a lot of information with a client, sharing documents on what is like a common Gmail or Yahoo account, that's the kind that they might say you didn't take reasonable precautions. Would that be a good example now, or do you think?
I am a firm believer in every particular instance needs to be evaluated in the instance in which it's occurring, not as a bright line type of a test, or, I'm going to tell you this rule and it's going to protect you, because every situation is different that we're confronted with. And so I would just say that, we have to remain vigilant. We can't stick our hands in the sand, particularly any longer, because, even the court system is becoming more technologically proficient. And, we have to adapt to that technology. And we have to show that we have an established, protocol, so that if you are ever questioned, on a particular instance by the bar, you can say, I do this, I have done this, I do this in all of my cases, I did this, took this step in this particular case. And it's a matter of being aware and taking whatever steps you can take to protect the confidences of the client and to protect the rights that you have of your own work product. And, one of the LA County Bar ethics opinion that came out, it's I think it's attached to the materials. 529 talks about an attorney who was talking on a blog type system through the internet, and these terms that I didn't know existed do exist. It's called catfishing, where somebody will go on and they'll start a communication with that lawyer and get information. They fake their ID, but they may be opposing counsel. They may be an opposing party in a case. And it's to draw out from that attorney certain information. And in this particular example, it was an attorney who disclosed expert witness information and other information. And the opinion says, if you do that type of a thing, you are revealing your own strategy, your own work product into the public view, and therefore you have waived that privilege. And there's also a Northern District of California case that is cited in that opinion. It's Lenz versus Universal Music. It was a 2010 decision where it talks about the use of the steps, and it wasn't where the attorney had even disclosed the names of the client or the names of the expert. It was just the information that was revealed. And so I would say, because I know that family law attorneys sometimes use listserv, to communicate information about their cases. And what you have to be aware of is that an opposing counsel could be on that listserv. And depending on the information that you reveal in that, you don't have to reveal names, but the geographics of the situation, identifying the judge, identifying, perhaps a peculiar circumstance in that case that you're seeking opinions on, that gets out to opposing counsel. I have seen and heard of instances where even judicial officers are on listserv sometimes. So, using these types of public access where, 20 years ago, 10 years ago, when we used it, it was a finite group. We knew who was involved in these. It's become much more expansive. So just be careful. Another opinion that deals with confidentiality is one that recently came out last month by the American Bar Association. And that is Formal Opinion 503. And it talks about a situation where an attorney sends an email to opposing counsel and includes his client or her client on that email as a CC. So you're dealing with a situation where does the fact that you included your own client on that email then impliedly consent to opposing counsel responding and including your client on that response? And the answer is yes, it is considered an implied consent to allow that attorney to communicate with your client through that means. It is not a violation of, I think it's Rule 4.2, which talks about you can't communicate with a client who is represented by counsel. That would be impliedly consented to by the attorney who sent the email. So you have to restrict the email response to the topics that are covered. It doesn't give you free rein to, say anything about the case to the opposing counsel and replying to all. But it does open that access for that limited period of time. So in that opinion, they talk about the fact that you may want to, and is recommended, that you send a separate email. Just forward the email that you had sent to opposing counsel, forward that email to your client instead of including them as a CC or a BCC, because even certain email platforms will include the BCC on any reply all. So you just need to be careful on that in terms of, and these are things that that we all use. The other aspect to the email is including your client on that email. Also, potentially, depending on the sophistication of your client, could result in your client responding to all and saying something that the client actually intended only to go to you as that client's attorney, but also went to opposing counsel or the opposing party, whoever's on that email. So you need to be very careful in terms of using people on as BCCs or CCs on emails. Since we are running out of time, we're going to run through the two more rules. The next one is the communication and communicating with the client. The rule says you have to keep the client reasonably informed of significant developments in the case. It's not only the case, but it is, this really goes to what if you did have a data breach of some kind, or what if there was the potential that you became aware of that the client's information could have been somebody, a third party had gained access to. So you do in that circumstance have a duty to communicate that to your client. So again, the tips are pretty much the same with all of these is, evaluate your level of security on your system, evaluate the client's sophistication with the use of technology, and gauge your case and how you're going to communicate based upon those factors to maintain the confidences. Explain the importance and then implement that mode of communication and constantly evaluate that mode of communication for each of your each of the cases because they're all different. The next aspect is supervision, and we've talked about this before, but the issue of supervision is covered by Rule 5.1 to 5.3. And if you have a managerial role over anybody, whether it is a staff person or an associate or your partner, you have the obligation to ensure that that person is complying with the rules, meaning that they're not taking a laptop and using public Wi-Fi that's not secure. They're not just willy-nilly clicking on any email that comes through, or they're not going to websites that are potential bad websites. So you, as the lawyer, do have that obligation of supervision over whoever it is that's handling your cases, both in terms of documents and in terms of communications. And you want to make sure that that is constantly supervised, that it's not just a one-time, stop that you hire somebody and you tell them, here's what we do, and don't do this, don't do that, or here's how we do this, here's how we do that, and then let it go. It's something that you constantly have to remind this person, here's how we communicate, here's what we do. And the communication and supervision goes to things such as is this person who you are supervising speaking with an opposing party? I've seen several state bar investigations recently where, someone in the attorney's office is communicating with an unrepresented opposing party. And lo and behold, that person is potentially giving legal advice to this opposing party. That needs to be something that everybody is cognizant of, and you as the managing attorney are supervising that so that it doesn't happen to you and you know what is going on. And one simple way to resolve that is that if you are handling a case where there is an unrepresented party, you can just direct your staff that there's to be no communication with the opposing party unless someone else is present, or there's some documentation to show that what has happened, what the discussion was, and that protects you from these kinds of claims. Jeff, do you have anything you'd like to add to that?
I mean, I think it all fits in with kind of what we've talked about thus far.
So I was trying to leave some time for any additional questions. It's 6:15, and technology is here to stay. We have to just not turn our back to it. We have to embrace it and be vigilant and diligent in terms of what we're using and how we're using it. There is a list of resources that are available that we've referred to and that are in the materials, and I'm happy to answer any questions. I'm sure Jeff will answer any questions that anybody may have. Hopefully this has been helpful to
On a technology glitch side, we need you to sign in right now with your real name to the chat room so we know that you're here, because the name got switched, and I don't want to go into it, but it would be really helpful to have everyone who's on the call, other than the panelists, to sign in as people are doing right now, because we're going to really need it. And does anyone have questions of Jeff and Jennifer in terms of their own practice, in terms of dealing with clients? Anybody? Great, everybody's signing in. That's great. That's great. Talking about, I had earlier questions in chat. One of the things that I'm just going to ask a couple. So like I've been on a call with our account on like a Zoom call with an accountant, and because of these pop-ups, she's getting like messages from her other clients. And I was thinking, well, that's not good. And what if you're on a Zoom and you're in court and, you know, you're getting pop-ups from other clients and stuff? Is it as simple as figuring out how to stop your pop-ups? I mean, is it, or at least turning it off for the period that you're talking to someone?
Yeah.
I mean, especially if you're giving a presentation, quit out of every other program on your computer. It's a good best practice anyway. I did it before this call. Close Outlook, you know, close web browsers, make sure that stuff is just not running, and then you're okay.
Right, so you just shut down your Outlook altogether. Okay, all right.
One of the things on mediation and the use of Zoom is chat rooms, and making sure that whoever your mediator is or whoever has set up that Zoom is somebody that is trustworthy, so that you can ensure that, or at least become relatively assured that if you are in a breakout room, that communication that is going on while you're in that breakout room is not accessible to anyone. And I've seen situations where, you know, people have offered to, you know, throw up their Zoom or whatever platform it was for a conference or something along those lines. And, you know, one of the other situations that has arisen is the ability to record when you have an approved recording, in whether it's in deposition or, you know, it could be a mediation, any environment where you are using a platform that is in the form of this, or like a Zoom or video conferencing, something along those lines. If you need to know how that system operates before you agree to it, so that you can prevent, you know, somebody recording it when it hasn't been authorized to record. You know, because you don't know what people are going to do, and people can, I've seen people do crazy things that you would never dream of. And it's just something that we have to know, what we're using and how we're using it and how can we best protect. So you always look up at the top, you know, or whatever could be down in the lower left on whether there's a red light, you know, that shows that it's being recorded, and then you can address it. Or you just make an affirmation at the commencement of whatever proceeding it is that, you know, I want whoever the participants are to state that they are not recording in any form or fashion, you know, what is going on here. And I've done that before, and I've questioned the witnesses who have set up their Zoom to make sure that it's not being recorded by them. So at least you would have that.
I think that's an important point, you know, to look for the Zoom recording, but also be aware that anyone of moderate technical skill could easily record the audio and or video of a Zoom without any way for you to know. So, you know, if if that's potentially a problem, then maybe Zoom isn't the right mechanism.
Right, so there's a question, if the client uses a firm like Staples to scan documents to you, which would be considered confidential documents, what are the risks of something like that? You know, they're going to a public copier because they don't have, you know, they're not sending it, you know, then, well, it's obvious. They're using a public scanner.
Well, so really it comes down to, you know, how valuable the data is. You know, certainly the risks would be what happens if the Staples employee is making a copy of everything everyone scans surreptitiously and then selling it at the end of the day. No, they shouldn't be doing it. And Staples would say it's impossible for that to happen, but we've all been to Staples and, you know, stuff happens. So it's weighing that risk. You know, I would think if you're working with a firm that specializes in doing legal work, you know, one that does e-discovery, you know, a specialized legal firm, then they would have more assurances of that sort of a thing, and they'd have a lot more to lose. But if this one person's documents got lost or copied, I don't think Staples would be that concerned about it. So yes, there's risk there. Now, how likely is that? On the scheme of things we've been talking about, not very. You know,
Well, I guess the question is it if the document is being sent through the internet, through the scanner, right? And let's say it has the client's social security numbers, and let's just say it might not, but that's what I thought the risk would be, that.
Well, it's just like, I mean, the way scanners work and the way copiers work these days is they always have hard drives in them. And almost every document they copy is left on that hard drive in some fashion. It's part of why, you know, when we decommission a copier, we always make sure to destroy the hard drives. So yes, the risk is there, but among the things we've talked about, I don't think that's a huge risk. It's certainly a lower risk than, you know, sending the documents through email.
Or phishing. Okay, another question is
also the kind of client who you may want to consider, is this a client who we want to use that resource? And maybe it is better off than when you need the client to sign something, just send them an envelope or her with an envelope that's stamped, and, you know, they can mail it back to you. It takes longer, but you know, you just have to evaluate each situation as it comes to you.
Yeah.
Another question is, what's your recommendation to firewall an attorney who may have a conflict when everybody has access to the cloud server? I guess in your own office, you might have an attorney. You may have it at your firm too. How do you set up the firewall?
So it's very specific to the software in use. You know, I mean, the document management system that we use at Haight allows us to, by matter, identify who can and can't have access to it. And it also logs everyone who accesses a document and when they did, so that we can not only prevent people, but we can definitively attest to who did see those documents. So, you know, it's going to be software specific, but and this is one of the things that you'll find in business class. So this is like Dropbox, for example, doesn't have a lot of great security in it. Whereas platforms like Box and, you know, ShareFile will have more granular security where you could do that sort of a thing. But it's definitely going to be very specific to whatever software you're using. But any good document management or sharing platform should have the ability to control who has access to which areas. And then the other side of it is you have to have a policy of putting documents in the right place, obviously, because if you know, you have the greatest security in the world, but everyone drops it in the J drive or whatever, then, you know, there it goes.
I have a case right now where we have exactly, well, it's not a conflict situation, but it's a situation where we don't want this opposing party who is very computer savvy to be able to, by any stretch of the imagination, somehow get into our system and get whatever attorney-client information there is. So we have special protocol on all materials related to that particular file that makes it private to anyone except for certain few people. And so there are ways that it can be done, but again, like Jeff said, it just depends on the platform that you're using, or the system that you're using.
Jeff, or Jennifer, rather, you talked about the family law listserv, because I just want to talk about that for a minute, because I've been shocked, really, and I remain shocked at the amount of information that people put on about their cases that identifies it. And I wonder if, I mean, I feel like everyone should be given an advisement that they shouldn't be. It's one thing to say, what's the new law on blah, blah, blah. But it's another thing. I've got a client in Judge so-and-so's courtroom, and she's got 3 kids, and she only, you know, makes $150 a week. And, you know, it's like, can you comment again on this, just so people leave with this understanding?
Well, like I mentioned before, is, you know, you need to know who has access to that listserv. What body of people are you throwing this information out to? And, you know, information as specific as you have mentioned, that opposing party or opposing counsel could be on that listserv. The judge could be on that listserv. So listserv is not like it may have been years ago. You know, there were practice groups where family law attorneys would meet. You know, just a small group of people, and you'd sit around the table and you'd talk about your cases. And I think that was the idea behind listserv, was that you could do that. But when you're sitting across the table from somebody, you know who that person is, and you know that person is not opposing counsel, and you know that person is not the judicial officer or any way going to be connected with the case. So you have some sense of security there. But with listserv, you have no security because you don't know who you're communicating to. So that's why I brought up this LA County Bar opinion 529, which talks about an attorney putting out information about a case without revealing names and numbers on social media. It's the same as listserv. And so you do potentially jeopardize your client's interest by using listserv. I haven't heard listserv being used as often as it used to be used, but I'm not in the family law arena, so I don't know specifically how much it's actually being used these days.
Do you have any parting words on social media? Any parting advice vis-a-vis yourself, meaning the attorney or the client? I mean, do you go by like the client shouldn't do anything on social media for the duration of the case, or what's your advice?
I definitely wouldn't use any kind of social media, whether it's even LinkedIn, as a form of social media. I don't use that to discuss any of my cases in any form or fashion. You want to post an article, you want to, talk about something that is a matter of public record, that's different. But I just shy. I'm one of those people that just get a little bit freaked out by all the technology. So I, particularly social media, I don't go down that path at all. And, we see social media being used for all different sorts of things. And it's just a dangerous environment. So. And
what do you say to clients, whether they be lawyers or not, about their use about social media and regarding a case that you might have?
I do talk to my clients about whether or not they use social media in any form or fashion, and I specifically advise them, if they do, not to use any reference to the particular case in the form of social media. And I think that's something that we all should probably advise our clients.
Well, it's been a great evening. Hopefully people will sleep tonight. Um, I want to thank the two of you. I want to thank Stephanie Chow and Debbie Lynn, our Harriet View High staff, volunteer coordinator and pro bono director, for organizing this, and for Jennifer, all the PowerPoint work that you put into it. Again, if you have not signed in tonight, you should do it right now. There's an evaluation form that was sent out, and we'll send it out again, but we're also soliciting ideas for future CLEs. So we really like your ideas, and we got we got a thank you to you, Jennifer and Jeff. And the evaluation form was also just posted, and we're getting some more thank yous as well. So
well, thank you, Betty. Thank you for setting this up, and I wish everybody happy holidays.
All right, thank you very much.
Thanks, everyone.
Good night.
Good
Bye-bye.
night.
Bye-bye.